Judgment in the matter of the Chief Constable of the Police Service of Northern Ireland and another against Agnew and others.
Lady Rose will hand down this judgment.
This appeal concerns the entitlement of police officers and civilian staff working for the police service in Northern Ireland to claim payment of sums which their employer should have paid to them as holiday pay when they took their paid annual holidays over the past few years. The claimants have been chosen as representative of a large group of police constables and civilian employees of the police service of Northern Ireland. The appellants, the Chief Constable of the Police Service of Northern Ireland and the Northern Ireland Policing Board are their employers. The employers accept that the claimants were underpaid, but there is an argument between the parties as to how many previous years of underpayment the claimants are legally entitled to claim for. This appeal involves the interpretation of a number of pieces of legislation. First, the Working Time Regulations Northern Ireland 1998 and 2016, which I will refer to as the Working Time Regulations. These regulations implemented the EU Working Time Directives 1993 and 2003 for Northern Ireland. Those European law directives required the United Kingdom to legislate to ensure that every worker is entitled to at least 4 weeks paid annual leave. There is no doubt that all the claimants have that entitlement. The question of how a worker's holiday pay should be calculated has been the subject of a great deal of litigation. The view for many years was that holiday pay should be equivalent to the worker's basic pay. However, it has since been established in case law that holiday pay should be calculated by reference to a worker's normal pay. This means that holiday pay should reflect an element to reflect overtime if the worker normally works and gets paid for work performed over and above their basic hours. The claimants were only paid their basic pay as holiday pay, but they regularly worked overtime, and now they seek to recover the amount by which they were underpaid. Their employers rely on a provision in the Working Time Regulations which would restrict the police officer claimants to claiming only sums relating to holiday pay which they were paid in the 3 months before their claims were started before the Industrial Tribunal. The claimants say that they can rely on an alternative provision in the Employment Rights Northern Ireland Order 1996, which I will refer to as the ERO. This provision would allow them to claim underpayments arising from a series of payments, provided that the last underpayment in the series was not more than 3 months before they brought their claim before the Industrial Tribunal. I will refer to this provision as the series extension. Of course, if the claimants can rely on the series extension, then their claim can cover many more holidays they took in previous years, going back much further than just the 3 months before they lodged their claims. So there is a very substantial difference between the value of the claim depending on whether they can rely on the series extension. The Industrial Tribunal held that all the claimants could rely on the series extension and that most, if not all, the payments they had received were in a series for that purpose. That meant they could claim back over a number of years and not just over the most recent 3 months. The employers unsuccessfully appealed to the Court of Appeal. The employers now appeal to the Supreme Court, and the Supreme Court unanimously dismisses that appeal. The first issue is whether the police officers are entitled to rely on the series extension. The series extension is included in the ERO, but not in the Working Time Regulations. The employers argue that the police officers cannot rely on that because they do not fall within the term workers for the purposes of the ERO, although they are treated as workers for the purposes of the Working Time Regulations. The claimant's position was that they are all entitled to rely on the series extension by virtue of the EU law principle of equivalence. This principle requires that national procedural rules applicable to rights conferred on people by EU law must not be less favourable than the procedural rules governing similar rights that are conferred by domestic law in the United Kingdom. The police officers argued that the principle applies in this case because the domestic remedy under the ERO is more advantageous than the remedy available to enforce their EU-derived rights to 4 weeks paid annual leave under the Working Time Regulations. The Supreme Court agrees with the claimants and holds that the EU principle of equivalence is infringed by the apparent inability of the claimants under the Working Time Regulations to benefit from the series extension available to workers under the ERO. The Court of Appeal was right to determine that the objective, purpose, and essential characteristics of the ERO and the Working Time Regulations are so similar that claims under the ERO should be regarded as domestic proceedings which are comparable to the EU claims for the purposes of the principle of equivalence. The appropriate remedy for the infringement is to construe the Working Time Regulations so that they comply with the EU principle of equivalence by reading in the series extension so that it now forms part of the Working Time Regulations, and this has the effect that all the claimants can rely on it. The second issue for the court is to determine the correct scope and meaning of the series extension, and this turns on the interpretation of the word series in the context of the relevant provision in the ERO. The employers argued that the Court of Appeal had interpreted the term too expansively. In particular, the employers contend that a gap of more than 3 months between any two unlawful payments or the making of a lawful payment should bring a series to an end, so that any future claim cannot extend back beyond that time. The Supreme Court upholds the Court of Appeal's interpretation of the series extension. The general purpose of the legislation under consideration is to protect workers against exploitation, and particularly to protect vulnerable workers from being paid too little. The series extension in particular provides protection against the operation of the short 3-month limitation period for a worker who suffers repeated but small deductions from their wages. Likewise, the court holds that a correct payment of holiday pay does not necessarily bring a series to an end. What constitutes a series is a question of fact that must be answered in light of all relevant circumstances. In this case, the Court of Appeal was right to find that each unlawful underpayment was linked by the common fault that holiday pay had been calculated by reference to basic pay only, and so they did all form part of the same series. The Supreme Court therefore unanimously dismisses the appeal.